certainly are. And in the area of family law, we have 3 or 4 major categories of what is considered child custody arrangements. The first would be considered sole custody. Sole custody is the traditional way people looked at divorce and family law breakups in the past, where automatically, if there were children, the wife would have the children. She would then be responsible for making decisions. The non-custodial father would be paying child support. She would have the sole responsibility, therefore sole custody, of making the decisions and what was in the best interest of the children. And the father would pay his child support and kind of be on the outside, and he would take his every other weekend visitation or what might be ordered to him, and that would be the primary way of looking at that custodial relationship. Then we have evolved from that. The psychologists have told us and the counselors have told us that that is not in the best interest of children. And what's in the best interest of children is having both parents be involved with the training, the rearing, the education, the disciplining of the children. As the result of that, we now have primarily joint legal custody with physical custody to one of the parents. And when we talk about joint legal custody, that is now defined in Indiana law also. Joint legal custody is defined as parents having to talk back and forth about 3 areas when it involves their children. One is education of the children. The second is religious training of the children. And third are the health care needs of the children. So if you have a joint legal relationship, regardless of who has the physical custody, both parents are under the obligation, before decisions are made for the children, to confer with the other parent to come together on a cohesive decision. We think Johnny should go to parochial school. We think he should go to Dr. Zamata, where these type of decisions, they should be raised within whatever religious background they may have. That is now by statute. Once you do that joint legal custody, then it's normal that one of the parents have physical custody. And that can either be the mom or the dad. Indiana does not preference either the female gender or the dad in having custody of the children. So you can have joint legal in making the decisions and physical with one of the parents. And the primary reason for physical with one of the parents is that children of the younger ages need the stability of where they're staying. They need to have that cohesiveness of knowing that 3 to 4, 5 days we're going to be at this particular home. These are what the rules are going to be. It doesn't mean that the non-custodial parent is pushed out because of the decision-making process. They are part of it, and they exercise and do what they need to do. From there, it can, in fact, even be expanded to split custody arrangements. Split custody arrangements are very beneficial for the children. A split custodial relationship may be where mom and dad literally may not be able to get along between themselves, but both of them have said, regardless of whether Dick and Jane, we can get along, we are going to do what we need to for our children.